Authority will come to order. Would the city clerk please call the roll?
Authority Chairman Bradish.
Here.
Vice Chair Cole.
Here.
Authority Member Levere.
Here.
Authority Member Mather. Authority Member Odell.
Here.
Authority Member Peterson.
Here.
Authority Member Webb.
Here.
We do have a quorum. Next item of business is approval of the agenda. Has everyone had a chance to review the agenda?
I'll move that we approve the agenda.
Second.
All in favor?
Aye.
Opposed? No. Motion carried. Next item, approval of certification of the minutes of the 11/12/2014 regular meeting.
I'll move that we approve the clerk's certification of the November 12th meeting record.
I'll second that.
All in favor?
Aye.
Opposed? No. Motion carried. Next item of business, item 6A, resolution to approve a liquor license application for Rancho La Playa LLC, doing business as Three Portillos Mexican Restaurant and Taqueria, 3625 West Bowles Avenue, number 16, Littleton, Colorado. We have exhibits A through G.
Correct.
We have a motion to approve the exhibits.
I will so move.
Second.
All in favor?
Aye.
Aye.
So the issue before the authority is whether to issue a hotel and restaurant liquor license to Rancho La Playa LLC, doing business as Three Portillos Mexican Restaurant and Taqueria at 3625 West Bowles Avenue, number 16, Littleton, Colorado. I have included in the council communication the following requirements necessary for issuance of the license. The application is complete and all required documents are in order. Therefore, should the applicant's presentation and the facts and evidence adduced as a result of your investigation tonight indicate that the needs of the adult inhabitants of the neighborhood are not now being met, that the desires of the adult inhabitants of the neighborhood are to have the license issued, that existing similar liquor licenses in the designated neighborhood are not adequate, and the applicant and registered manager are of satisfactory record and reputation, we would recommend that you approve the application for the liquor license as requested by the applicant.
The applicants represented this evening? Good evening.
Good evening.
I'm required to swear you under oath before we proceed.
Okay.
Do you swear or affirm that the testimony you're about to give before this authority is truthful?
Yes.
Thank you. Who's the spokesperson?
I'm Carol Johnson with Esquire.
Walk up to the microphone, please.
I'm Carol Johnson with Esquire Petitioning Services. Do you want me to review?
Carol, can you speak up a little bit, please?
It's Carol Johnson with Esquire Petitioning Services. And did you want me to do the summary review first?
Am I the only one that's having trouble hearing?
No.
I'm having.
No.
Then we're having something adjusted.
It's just about to get better. There we go.
There we go.
Oh, that's much better.
Thought it was me. Thank you. Proceed.
Okay. We did the summary of the needs and desires for this restaurant, and we did a total of 270 door knocks, of which 93 people signed the petition, 16 declined to sign, 17 were ineligible, and 155 did not respond to the door. We had 74 residents and 18 business owners or managers for a total of 92 in support of the issuance for 98.9%. We had 1 resident and 0 business owners or managers in opposition for a total of 1.1% for the total of 93.
We had, the reason was a non-applicable reason that was given, so that in the final analysis of needs and desires, we have 92 signatures for 100% in support of the license. And I will answer any questions you may have.
Any authority members have any questions regarding the petition?
No, as usual, thorough job. Thank you very much.
Do you have any questions for us? She will be the manager and I'm the owner, so.
Okay.
So.
Do you want to just tell us a little bit about the establishment?
Sure. As an owner, I have owned, I'm a nurse right now, but as an owner in the restaurant business, I've been 13 years. We own 2 restaurants, one in Littleton, which is by Ken Carroll area, and the other one in Parker, which has been open for 5 years. We never had any violence, any violation of that always. Parker is really hard. We get checked every 3 months. Littleton, not so bad. But we always have training on the employee who will get a letter every year of offering them, training for the employees. We send them to, any new information that they need to be aware. And we always try to, have our liquor stored and nobody else touches it, make sure they check their IDs. So we're really good on, getting our employees trained. And she's been with us 10 years. So that's the reason she's very honest and very precise with her work. So that's the reason I chose her to be one of my managers here in Littleton.
So your other restaurant is a Littleton mailing address, but it's not in the city of Littleton.
It's by Ken Carroll and Sims by the Chatfield area. That's where it's located.
Okay.
And that one's been open 13 years.
Just reviewing your floor plan, it doesn't look like you have any bar space or anything. It's just strictly table service.
Yes, service bar.
Apologize for the coughing. Can you give us an idea when you'll open?
It took forever, a year and a half to get all these processed, and I think it was from the tenant upstairs. And it was just hard getting everything set up just where it's located, but probably within the next month. That's what they said. All the hoods and everything, they're in there, which was the hardest part to get it installed. But the grease trap, it's there, so it's just getting everything together with the health department.
Thank you.
Thank you.
I have a soft spot in my tummy for Mexican food. So, how soon are you planning or anticipating opening?
A month. That's what I just
About a month.
told them,
Okay.
about a month.
And how many employees?
Oh, it's a very small restaurant, so maybe from 3 to 5.
Okay.
Yeah,
fine.
I think the capacity is the most maybe 40 people. I think 32 to 40 people.
And with all the experience you have, I'm sure you probably have arranged to let me know about tips training for those who are going to be handling alcohol.
Oh, yes. We always have training
Thank you.
for all of our employees.
Did you say all of your employees will be tips trained?
No. I mean, some are, my husband will be here, so my husband, myself, and I will be running the place, and maybe just an extra employee. Because, it's so small, and then the cook and the chef, that's it. So whoever's going to be working there, we all have experience.
And what's your policy on IDing people? Do you ID based on a certain age, or do you ID everyone? Ask for an identification.
Oh, what do you mean, what's my policy? First of all, I don't, usually if they're not be mean, but 60 or older, I don't really check
Why did
ID.
you point at me?
But anything that I think it's anything under that age, I always check them just in case, especially anybody that has veer, had, leaning down. Mm-hmm. I don't care how busy I am. Always, take the moment because that could be a huge impact in them and us.
That's the preferred policy that we would like to see you follow, because you take the judgment away from yourself and just check everybody.
Yeah. Especially,
What percentage of your sales do you think will be alcohol?
Oh, Not much, especially. I mean, for us at the other two locations, we have full service bars, and our sales there are like maybe 8 to 10%. So here it's probably not even that much. It's just to give them that convenience of people, who wants to eat Mexican food, have margaritas because it's a strong point. So just have the availability that if you want to go and have a good dinner, have wine or beer. So, but our sales, we're just thinking that it's not going to be a huge impact on our sales.
Okay. So there won't be people that go here to drink? They'll go here to eat, and if they want to drink, it'll be available.
Well,
okay.
A bar will not be available for seating, so.
Well, I have no further questions. Do other members have any questions or anything else you'd like to add?
No, that's it.
Does the city attorney have any comments?
No, but this is a public hearing, so we need to make sure that there's no one from the audience that would like to speak, as a reminder.
Thank you. Anyone here to object to this license that would like to speak?
Or support it.
Or in support of? Thank you. Appears to be none. I think we can close the discussion, and I would ask if we're ready for a motion.
I'll make a motion. I move that we close the public hearing and that a resolution of the Littleton Licensing Authority be approved, which grants Rancho La Playa LLC, doing business as Three Portrios Mexican Restaurant and Taqueria, 3625 West Bowles Avenue, number 16, Littleton, Colorado, a hotel and restaurant liquor license contingent upon approval by the Colorado Liquor Enforcement Division and based upon the following findings of fact. 1, the notice of the public hearing was properly posted and published. 2, that the applicant has possession of the premise and the premises are suitable for the requested license. 3, that the needs of the neighborhood are not now being met. 4, that it is the desire of the adult inhabitants of the neighborhood that the license be issued. 5, that existing similar liquor licenses in the designated neighborhood are not adequate. And 6, that the applicant and registered manager are persons of good moral character, record, and reputation.
I second the motion. Will the city clerk please poll the authority?
Authority Chair Bradish?
Yes.
Vice Chair Cole?
Yes.
Authority Member Lavier?
Yes.
Authority Member Odell?
Yes.
Authority Member Peterson?
Yes.
It is unanimously passed. Congratulations.
Thank you.
Good luck with your business.
Thank you.
And good luck with controlling the serving of your alcohol.
Thank you. And I'll ask for your ID then.
Night.
Right.
Next item of business, item number 8, findings of probable cause and scheduling of show cause hearings for liquor code violations. Item A, determine if probable cause exists to set a show cause hearing. Vasilios Fraginkakis, doing business as Old Mill Brewery, 5798 South Rapp Street. I think all members of the authority have had a chance to review the police reports.
Do we need to admit? Well, do we need to admit?
If I could ask you to admit the proof of notification and the attached LPD reports into the record.
I'll move that we enter those exhibits.
I'll second that.
Although there's one attachment to proof of notification. I make a motion that we approve the attachment proof of
Vice Chair
notification.
Cole already made a motion, and we have a second. We just need a vote.
Okay. All in favor?
Aye.
Aye.
All opposed? No. Motion carried.
So the issue before the authority tonight is whether or not whether there's probable cause to believe that the licensee violated the Colorado Liquor Code and Littleton City Code and should be scheduled for a public hearing for show cause, if any, to see whether its license should be suspended or revoked. This matter comes to the authority as a possible violation of the Colorado Liquor Code and Littleton City Code following citation of the licensee's employee on November 5th, 2014 at approximately 9:50 p.m. at the licensed premises. Possible violations for the authority to consider this evening are Littleton City Code 3-2-11A2, Conduct in Establishments, which states each licensee and employee shall conduct his establishment in a decent, orderly, and respectable manner and shall not permit within or upon the licensed premises the loitering of habitual drunkards or intoxicated persons, lewd or indecent displays, profanity, rowdiness, undue noise, or other disturbance or activity offensive to the senses of the average citizen or the residents of the neighborhood in which the establishment is located. Any licensee hereunder and any manager, agent, or employee of a licensee hereunder shall immediately report to the city's police department any unlawful or disorderly act or conduct committed on the licensed premises. Additionally, I'd ask the licensing authority to consider a violation of Regulation 47-900, Conduct of Establishment. That regulation provides that each person licensed under the Colorado Liquor Code and any employee or agent of such licensee shall conduct the licensed premises in a decent, orderly, and respectable manner and shall not serve a known habitual drunkard or any person who displays any visible signs of intoxication, nor shall they permit a known habitual drunkard or any person who displays any visible signs of intoxication to remain on the licensed premises without an acceptable purpose. Nor shall the licensee, his employee, or agent knowingly permit or any activity or acts of disorderly conduct as defined by state statute. And I did want to include that in the record because of our system. It was in a footnote and our system didn't pick up on it, so I wanted to let you know what the definition of disorderly conduct under the statute is. It says a person commits disorderly conduct if he or she intentionally, knowingly, or recklessly makes a coarse and obviously offensive utterance, gesture, or display in a public place, and the utterance, gesture, or display tends to incite an immediate breach of the peace, or makes unreasonable noise in a public place or near a private residence that he has no right to occupy, or fights with another in a public place, except in an amateur or professional contest of athletic skill. And then the other two, let's say, not being a peace officer discharges a firearm in a public place except when engaged in lawful target practice or hunting, or the ritual discharge of blank ammunition cartridges as an attendee at a funeral, or not being a peace officer displays a deadly weapon, displays any article used or fashioned in a manner to cause a person to reasonably believe that the article is a deadly weapon, or represents verbally or otherwise that he or she is armed with a deadly weapon. I will note for the authority that the suggested motion, if the authority finds that there is probable cause to move to a show cause hearing, the suggested motion includes a date for a preliminary hearing, but the prosecutor has indicated that if the authority finds probable cause, she will not be proposing a stipulation. So we would ask that if you do decide to set a show cause hearing, you go ahead and set it in January.
Thank you.
I have a question on the Littleton City Code 3211A2.
Mm-hmm.
Often when we see this, the disorderly conduct is centered on either habitual drunkards or intoxicated persons. I just want to make sure I'm reading this sentence correctly, that the other behavior in here, lewd or indecent displays, profanity, rowdiness, undue noise, or other disturbance, are discrete from intoxicated person. I mean, they are not part of, they are their own offense, if you will. You don't have to have an intoxicated person in order to.
Right, correct. So the way you would read it is that, first of all, that they must conduct their establishment in a decent, orderly, and respectable manner. And they will not permit the loitering of drunkards or intoxicated persons, and they shall not permit within or upon the premises lewd or indecent displays, profanity, rowdiness, undue noise. It's not related to the drunkenness.
Okay.
So the confusion is that that's all one sentence, and the implication would be that intoxicated people can't be loud and obnoxious, but nobody can. Even that.
Right.
That's fine.
May I ask, though, continuing on that line of thought, we get to the end of the sentence where those are actions that, to the senses of the average citizen or the residents of the neighborhood in which the establishment is located. So are those things that are outside the establishment that the establishment brings in, and people are loitering in front of the establishment, and the passers-by not within the walls of the establishment, that's where it gets implicated.
I'm not sure I understand your question. It is the modification, or it's saying that it needs to be offensive to the senses of the average citizen or the residents of the neighborhood in which the establishment is located. So I think it could be just sort of generally offensive to the general population, but also it could be a disturbance that is disrupting the surrounding neighborhood.
Okay.
Did I answer your question?
Yeah, I wonder if a person inside the restaurant is a patron of the establishment and not a resident of the neighborhood.
Mm-hmm. I think that would fall under offensive to the senses of the average citizen, assuming that they are have the senses, similar senses of an average citizen.
I would read this to be any citizen who's within hearing or visibility range of this conduct.
Mm-hmm.
Can the city attorney provide us with an update on the filing of charges in this case?
I can. One moment. So the charges that were filed is violation of 6421 assault, 6472C disorderly conduct, fighting with others in public, 64121A obstructing a peace officer, and 64124 failure to obey a lawful order. He is set for pre-trial on Monday, December 8th.
Those are all city misdemeanor assaults, though, or charges, right? Not a felony assault, class 3 or 4?
Correct. It's all misdemeanor municipal charges.
Okay.
And just to confirm, I'm assuming because it isn't in our staff recommendation that there's no additional criteria regarding staff or ownership or management of an establishment beyond the orderly conduct required of anyone who is at the establishment. Like there's no different threshold or other regulation or anything like that. Is that correct?
These are the two code provisions, the Littleton City Code and the Liquor Code, that I think are applicable to this incident.
Okay.
As long as everyone's asking questions, I have one of my own. I think I know the answer, but I'd appreciate a clarification. The first part as to the owner or the employees permitting this, would the benchmark for that, as I understand it, is the fact that they did not call the Littleton Police Department. That would be the benchmark for permitting?
I'm not sure I understand.
If someone's engaged in a fight, how do you permit that? Do you jump into the fight? It's my understanding that the benchmark for the establishment, the licensee, for permitting that is them not having called the Littleton Police Department. Is that correct?
I would guess that's correct, that I'm not sure we want people putting themselves in the middle of fights. But in this instance, we have an employee that is fighting in the establishment.
I understand, yes.
So to say it was.
And in your legal opinion, that if he was fighting and not in self-defense, that would constitute permitting?
Yes.
Thank you.
I might try to simplify this one more time and say that beyond the first sentence, maybe the rest of the paragraphs don't apply, but the first sentence is on the regulation 47-900 and Littleton City Code, that each licensee and employee shall conduct his establishment in a decent, orderly, and respectable manner. And I think going any further into the regulation than that sentence isn't required.
Yeah, but doesn't A2 compel the licensee to immediately report to the police department any unlawful and disorderly act? Is that a correct reading?
Yes, it does. But I agree with Authority Member Levere that, in my opinion, the licensee did not conduct his establishment in a decent, orderly, and respectable manner. But in addition, I also think there were the permitting on the licensed premises of an intoxicated person who was an employee, lewd or indecent displays, profanity, rowdiness, and other disturbance or activity that would be offensive to the senses of the average citizen. And I think there was a failure to report. If I remember correctly, the reporting came from a witness or the victim. I'm not. I'd have to check.
So it looks to me like there's two bases for probable cause. One is the behavior was tolerated, and two, it was not reported to the police department.
Correct. And I mean, I think
they're almost the same violation, but there's two parts of it.
Yes, but I think also an aggravating, this isn't just permitting it, this is actually an employee that is.
I understand that,
okay.
But even if it weren't an employee, the probable cause would still be there.
Yes.
Unless there are any other questions, I
just have one more
yeah,
question. Is there no city code or municipal code about operating a liquor establishment while intoxicated?
I would say that this provision addresses that.
Covers that?
Mm-hmm.
Okay.
Because you're not to permit upon the licensed premises, an intoxicated person to remain. And so if your employee is there intoxicated, you're in violation of this provision.
Okay.
From my reading of the police reports, I think there is probable cause that the licensee did not conduct the premise in a decent, orderly, and respectable manner, and that obviously the behavior was offensive to the senses of at least one average citizen who was there and became implicated. So I'm going to make a motion. I'm going to move to find that there is probable cause to believe that Vasilios Frangiskakis, doing business as Old Mill Brewery, 5798 South Rapp Street, Littleton, Colorado, on November 5th, 2014, did violate the Colorado Liquor Code and Littleton City Code. Based on these findings, I move that a public hearing be set for
January 14th.
January 14th, 2015, for the purpose of considering the status of their license, wherein the above-mentioned licensee may be present to show cause, if any, why its license should not be suspended or revoked, and further that notice of these findings and the hearing to show cause shall be forwarded and served to Vasilio Frangiskakis, doing business as Old Mill Brewery, 5798 South Rapp Street, Littleton, Colorado, in accordance with the provisions of state law.
I will second.
Would the city clerk please poll the authority?
Chairman Bradish?
Yes.
Vice Chair Cole?
Yes.
Authority Member Levere?
Yes.
Authority Member Odell?
Yes.
Authority Member Peterson?
Yes.
The motion is approved unanimously. There will be a preliminary hearing in our January meeting.
A show cause hearing.
I'm sorry.
Show cause. And just
Show cause.
For the purpose of procedure and anyone who might be watching, it's the prosecutor's discretion to not pursue a stipulation, right?
Correct.
Okay. And so she's indicating, I mean, that's why I made the motion, but I just want to make sure that for anyone out there to know that there's no point in setting a preliminary hearing if the prosecutor has indicated that she's not going to pursue it.
Right, she has to negotiate and make a recommendation to you. And
she's letting us know she won't be doing that, so there's no reason.
Correct. So.
I would like to make this request, that the authority be able to evaluate the stipulation put before it. Would it be proper for the city to inform the authority members of prior violations as to their nature and date?
Just to clarify, there won't be a stipulation placed before the authority.
I'm sorry, say again?
There will not be a stipulation brought before the authority on this matter. It'll just be a show cause hearing that'll come to you in January, and at that time, the prosecutor will present evidence about previous violations for your consideration.
Next item of business. We're down to reports.
None.
City clerk is indicating there is no staff reports. Authority members, I don't believe, have any reports or discussion, and the chairman does not. Being no further business before the authority, this hearing is closed.